Good afternoon, everyone, and good morning to those of you in the West Coast. Welcome to our program today entitled Election Year Activity, How Your Nonprofit Can Be Legally Active in the Political World. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Practice here at the Venable Law Firm. And welcome to this program, which as many of you know is part of our now 6-year running strong programs on various nonprofit legal issues that we do every month here in our Washington, D.C. office. For those of you who are able to join us, like about, 75 of you were able to make it here today for today's lunch, and always come and join us for lunch if you're able to. And then we do these programs from 12:30 to 2 o'clock Eastern Time with a live webinar component, and we have folks out in about 200 of you from around the country today participating in today's program. I'll get into the details of the program in a minute. A few housekeeping tips first. First off, these programs, for those of you in the trade and professional association community and who are CAE certified, these are eligible for a continuing association executive continuing education credit. Preview of our upcoming programs. We actually have 4 already scheduled this year. First, on June 21st, our program is entitled Investigating Employee Misconduct in the Nonprofit Workplace. Always a very hot topic, one that always seems to draw a lot of interest. It's an area in which, not surprisingly, our nonprofit practice and our employment lawyers do a lot of work counseling our nonprofit clients, and it's sure to be a terrific program. We have one of our partners in our labor and employment practice who works closely with many of our nonprofits, as well as an in-house practitioner from the outside. And incidentally, on the topic of employment-related issues for nonprofits, many of you, I'm sure, have heard about the new U.S. Department of Labor regulations that were finalized and released yesterday regarding overtime issues and non-exempt employees. It's a very significant development that's going to have a very significant impact on many, if not most, nonprofit organizations. We just, within the last hour, sent out our alert summarizing the new rules and what they mean for nonprofits. In addition, a couple days ago, we put out an article, an alert on compensable time for non-exempt employees. If you are non-exempt, what kind of time do you need to compensate those employees for, and what don't you, and lots of practical tips and pitfalls and traps to try to avoid. Those two pieces together are going to be very important and helpful to you. We also did one of our monthly programs on this topic just a few months ago, and there's a link to the webinar recording of that in the alert that went out today. For those of you in the room, you have a handout booklet that has a copy of the PowerPoint slides from today's program, along with our full bios of our speakers. I'm not going to do their bios justice today, but feel free to take a look at their bios in the handout book. And then we did include a number of articles, including a couple brand new ones that we just released on these topics, many of which we're going to be covering here today. So I encourage you to take a look at those articles. Those of you on the phone will receive an email tomorrow, all of you will, that will contain a link to the recording of today's program, along with the PowerPoint slides and the bios and all of the ancillary articles. And all of these recordings for the last 6 years' worth of our monthly programs can be found on our nonprofit YouTube channel. The link to that, along with the link to the massive collection of articles and PowerPoint presentations on every conceivable nonprofit legal topic, can be found on the last slide of today's presentation. During today's program, we do encourage you to ask questions throughout. For those of you in the room, just raise your hand when you have a question. I'll call on you, and then wait for the microphone to come to you before asking the question, so those of you on the webinar can hear. And those of you on the webinar, please pose your questions to me using the chat feature on the webinar software. Finally, last but not least, our speakers here today. To my immediate right is Ron Jacobs. Ron is a partner in our nonprofit and our political law practice. He also co-chairs our political law practice. Ron and I have worked together for many years, in fact most of the years that I've been at Venable. He's an integral and key member of our nonprofit group as well as our political law group, really straddles both sides of the fence extremely well, is very well versed in the broad array of all of the legal and tax issues that come to play in the regulation of nonprofits, lobbying, and political activity. As you're going to hear today, one of the reasons this area of law is so complex and difficult to get your arms around is that it's governed by so many different bodies of law and regulations. On the federal side, you have the federal election law enforced by the Federal Election Commission. You have the Federal Lobbying Disclosure Act. You have tax law considerations that come from the Federal Tax Code, different rules for 501c6 and C4 organizations, as well as 501c3 organizations. You also have congressional gift and ethics rules, federal gift and ethics rules, and then on the state side, you have corresponding laws governing lobbying disclosure and registration and reporting, as well as state gift and ethics rules. And so there's no shortage of governing law in this area. And in many situations when you're trying to figure out what can I do, what can't I do, what are the limits, what are the rules, you really have to take a number of those areas of law and put them together on top of each other to get the right answer. And both Ron and Larry are very, very good and efficient at doing that, as you'll hear today. To Ron's right is Larry Norton. Larry also is a partner in both our nonprofit and political law practices and is the other co-chair of our political law practice. Larry actually got his career, law career started at Venable as a first-year associate, went in and did a variety of some high-level federal government service, including most recently as general counsel of the Federal Election Commission before coming back and joining us here at Venable. He's a wonderful colleague, extremely knowledgeable in this area, and you're going to learn a lot from him today. And both, of course, work extensively with our nonprofit clients on all of these issues. So with that, I'll turn it over to Ron to get us started. Ron?
Great. Thanks a lot, Jeff, and thanks everyone for coming today. We really appreciate it. So with the election year here, we thought we would really focus on sort of 5 broad topics today. We'll start with an overview of some of the key legal concepts that underlie a lot of what we're talking about. We'll have a section on 501c3 activity, and then we'll have another section on 501c4 and c6 activity. We separate those buckets because the rules really are very different for those different kinds of organizations. And so what C3s can do and what C6s can do really need to be covered in 2 separate areas. Then we'll talk about political action committees or PACs. And we'll finish up talking about Super PACs, the kind of exciting, brave new world that we face and see a lot of their activities on TV as we plunge through this election season. So we'll get started with an overview. And again, think of this as sort of the legal framework that governs all the different pieces that we're going to talk about and really sets the stage for what we're talking about. So the first thing we want to cover is sort of the basic campaign contribution rules. As Jeff said, the Federal Election Commission governs these rules, provides these rules at the federal level. Each state has its own campaign finance rules. So we're going to focus, this slide kind of talks about the federal rule and a little bit of just a high-level summary of the state rules. If you're going to be politically active at the state level, you'll need to know each of that particular state rule in depth. So some of the kind of key concepts. Corporations at the federal level may not make contributions to candidates. Now, everyone sort of does a double take when I say that because everyone thinks Citizens United, the president hates it, a lot of people hate it. Corporations can give all kinds of money in the political process. And the answer is they can, but corporations can only be involved in independent expenditures, which is a concept we'll talk about in a second. But they cannot write a check from their corporate treasury funds directly to a candidate. Whether it's a for-profit or a nonprofit, at the federal level, that can't happen. So we'll unpack that in a little bit, but that's kind of the first basic rule. The state laws vary. Some states allow corporate contributions, other states don't. The next one is a broad prohibition that's important to keep in mind, and that is that foreign nationals may not contribute to candidates, political parties, or political action committees at the federal, state, or local level. Federal law governs there, and it applies at any level of political activity. So to the extent your members are foreign nationals or you have international support, you've got to be very careful about this rule. By foreign national, we mean someone who's not a U.S. citizen or a permanent resident alien. Government contractors is another area to think about. At the federal level, government contractors are not allowed to make political contributions, but this generally applies at the individual level, so an individual government contractor, because corporations that are government contractors are already prohibited from making contributions, but they're still allowed to have a political action committee. So it's a fairly limited scope. The state law varies widely on government contractors. So in some states there are broad prohibitions on giving if you're a government contractor. Other states have disclosure rules. It's important to you all, to the extent that your members are government contractors, they need to understand what their limits are if you're involved at the state level. And finally, there's sort of a concept of reimbursements to keep in mind. This is, I would say, the one that gets enforced criminally most often, and that is that if I want to make a contribution, I can make a contribution. If Larry wants to make a contribution, Larry can make a contribution. Larry can't reimburse the contribution that I make or ask me to make a contribution and give me the money to do that with. Each individual has to make their own contribution. Companies, to the extent they're allowed to, it's the state level can make their own contributions, but you can't pay someone else to contribute for you. And that, as I said, is a criminal it's enforced criminally. We've seen folks recently facing jail time for doing this. It's something that seems kind of obvious, but it isn't to a lot of people, and it's one that you've got to be careful of as you get involved in political activity. The contribution limits, again, we're going to focus on the federal level here. At the state level, they vary widely, but basically the concept is, and this always surprises people as well, how low the numbers are. Individuals can give $2,700 per election to candidates. That's it. Now you hear, gee, there's a fundraiser that's going on, they're soliciting $50,000. Well, that's going to involve other entities, political parties, maybe political action committees, things like that. But for candidates, it's a $2,700 per election limit. Political action committees that are multi-candidate, they've reached multi-candidate status, are allowed to give $5,000 per election. And when we get to the PAC section, we'll talk about what makes something in multi-candidate versus non-multi-candidate. There's different limits to the national party committees and then to state and local committees as well. And any giving you do at the state level is subject to state law. And I mentioned before the distinction on corporations between contributions and expenditures. And these are, again, sort of setting the stage for some key terms. A contribution is something that when you make a payment directly to a candidate. So if you write a check, hand it to the candidate, that's a contribution. If you provide a candidate a discount on a service, that's a contribution. If you do something at the request of a candidate, hey, can you give me print some yard signs for me for free? That would be a contribution to a candidate. On the other hand, there's these things called expenditures or independent expenditures, which are things that you do on your own, you, your association, whatever it may be, where you spend money to support a candidate or oppose a candidate, as long as you don't do it coordinated with the candidate. So the candidate can't ask you to do it. You can't say to the candidate, hey, we're going to do this. The difference is that contributions are limited and subject to all those restrictions I just laid out. Expenditures are unlimited. So you're allowed to spend as much money as you want on expenditures, and you can raise unlimited money for expenditures. And this is where that Citizens United concept comes in. Corporations are allowed to give to entities that make expenditures in an unlimited amount. And then finally, sort of to set the stage on the nonprofit side here, the tax law issues that come into play. 501c3 public charities are not allowed to intervene in campaigns, and this is really why we have the two separate sections here. So no endorsements, contributions, or communications to support candidates, whereas C6s and C4s, as well as C5s and some others, are allowed to be involved in campaign intervention as long as it's not their primary purpose. And we're going to unpack sort of what all that means in a minute. On the C3 side, lobbying is permissible as long as it's not a substantial part. C6s have unlimited lobbying. And then in terms of issue advocacy, C3 can do as much issue advocacy as it wants as long as it's not lobbying, but it's lobbying that's subject to that limit. And C6 can do as much issue advocacy as it wants without any concern over whether it's lobbying or not. Just to kind of further set the stage, lobbying is, when we talk about that, it's influencing legislation, talking to certain government officials about whether they should pass a law, modify a law, etc. Campaign intervention is when we're really talking about supporting or opposing candidates. Those are further terms we'll unpack, but just to kind of make sure that everyone's thing is clear. And then the last little sort of piece to keep in mind as we get ready to talk about some specific activities is that we will talk about candidate visits when you invite candidates to events at your facilities or at annual meetings and things like that. When we talk about that, we really mean candidates in their capacity as candidates. Separate from that, you can always invite a person who's a candidate in their other capacity, so their non-candidate capacity. So a sitting governor who's running for the Senate can be invited to speak as the governor, not as a candidate for Senate. A city council member can be invited as a sitting city council member, not as a candidate for the city council. And so if they're in their official capacity, it means they're not subject to the campaign finance rules, they're not subject to the campaign intervention. You just want to make sure you're keeping it separate and really focused on the official side of things, not the candidate side. So with that, I will turn it over to Larry to start talking about the 501c3s.
So there's a common misunderstanding that we hear all the time from our charity clients, and that is that they can't engage in political activity. What we want to talk about today, we want to disabuse you of that myth, but talk about what you can and what you cannot do. And the important thing to remember as a 501c3 is there are certain lanes where political activity is perfectly appropriate, don't pose any risk to your tax-exempt status, and other sorts of things that the 501c3 cannot engage in at all and would pose risk to the tax-exempt status, and some basic rules to keep in mind as you navigate those differences.
And one thing, sorry to interrupt, but a good point to keep in mind is don't get confused by labels. Larry's referring to political activity generally, and that can mean a lot of different things. As Larry's going to talk about, one thing that's clearly off limits, as you see in this slide, is no campaign intervention, which some people call political campaign activity. That's certainly distinguished from what Larry just referred to as lobbying activity, which is permitted but is limited for 501c3s. But the key is when you hear the word political or political activity, you need to look beyond the label to get into the details of what's allowed and what's not.
That's exactly right, Jeff. What the IRS means when they say the 501c3 can engage in political activity, they mean that you're not allowed to do anything to support or oppose a candidate for public office. Now, in the IRS view, ballot initiatives are not political activity because they don't involve candidates, and nonpartisan activity that doesn't attempt to support or oppose a candidate for public office isn't considered improper. So these are the basic no's. You can't make contributions as a 501c3 to a political candidate. You can't use your resources to fundraise or provide other kinds of support. You can't donate your computer equipment to campaigns if you're a 501c3. You can't host activities that are intended for the purpose of supporting a candidate or benefiting a candidate, and a 501c3 can't endorse a candidate. All this sort of falls under that general prohibition on supporting or opposing candidates for public office. But there's a lot that a 501c3 can do under the IRS's concept of permissible and impermissible political activity. And here the big bucket is that what you can still do as a 501c3 is certain nonpartisan voter engagement and educational activities, things that are really designed to promote citizen participation in democracy. So you're permitted to interact with office holders and candidates, which is important for any organization, and including 501c3s. You may host debates and forums subject to certain rules that we'll talk about in a second. You're permitted to communicate on issues. Again, we'll talk in a moment about where the limits are there. And you can even use scorecards, kind of scorecards on legislative records, voting records, and questionnaires if certain rules are observed. So debates, it's proper and appropriate for a 501c3 to host a candidate debate. And again, we sort of fall back on that rule that the debate has to be conducted in a way from the invitation right through the conduct of the debate itself in a way that doesn't suggest that the 501c3 is favoring any candidate over any other. So it's important that all candidates are invited. The IRS has said that it's permissible for a 501c3 to host an event with all the candidates who are in one party's primary or another. It could host an event with all the candidates for the Democratic primary. And it's also okay for a 501c3 if you're trying to make the event sort of manageable size to have some reasonable and objective criteria for determining who's in, which you saw the networks do in the debate, similar to what the 501c3 can do. You need to be over a certain threshold in polling, for instance.
One of the things that we've seen with some of our clients, it's one thing to say, an objective criteria at a presidential debate level where there are 15 polls that have come out in the past 2 weeks. It gets interesting when you're dealing with the local level where there may not be a lot of polling, and so you really have to work to either find the poll or come up with some objective criteria. Maybe they've already qualified for the ballot, or they've crossed some threshold, so that you have those objective criteria that are a little harder to find. It takes a little more creativity sometimes.
Now, Jeff made the point earlier, and we'll come to this again and again, is that for all of this activity, there's this overlay of regulation. The IRS, the Federal Election Commission if you're dealing with federal candidates, and state election laws if you're dealing with state candidates. The Federal Election Commission, for instance, would not permit the 501c3 to go forward with the so-called empty chair debate. So even if you've taken the step of inviting all the candidates, say 2 candidates who are running in the general election, and one of those candidates declines to appear, if you're talking about federal candidates, you're not going to be permitted to go ahead, because in that case, the organization would be viewed as providing an in-kind contribution to the candidate. Same principles apply with respect to candidate forums. If you want to invite candidates to come and speak and sponsor that event, not to be there at the same time to debate, but to appear at different times before an audience. It's similarly with the debate. It's important that every candidate receives an invitation, that they get equally good times and opportunities, that the questions are neutral, and that there's a variety of questions that don't project an agenda but give the candidate an opportunity to talk about a wide range of issues. Again, important thing for forum and debate is providing an equal opportunity to respond and present views. You should not, in the context of a forum or debate, ask the candidates whether they agree or disagree with the positions of your organization, statements you've made, your agenda. And the reason for that is that if one candidate says, yes, I support that view, and the other doesn't, that could be perceived as favoring or disfavoring a particular candidate. So you have to bend over backwards to be neutral here. No implications of approval or disapproval, no fundraising. You want to maintain a neutral atmosphere, which means that you want to make sure you invite people who kind of across the spectrum and not stack the crowd with folks who are either favor or hostile to the candidates who are appearing.
Larry, before you move on, we have one question from the webinar, which is a good one, which is, what happens if a person in the audience at one of these forums asks a non-neutral question of a candidate at a debate, namely a very biased partisan question from one side or the other?
Right. So that's fine. You can't, obviously, as the 501c3 organization, take control or be held responsible for everyone in the audience. But again, I think what you want to be particularly careful about is not stacking the audience with partisans who favor or disfavor that candidate, because if that's what you've done, then you as an organization have crossed that line from nonpartisan activity to suggesting that you support the candidate or oppose the candidate who's appearing. So candidate questionnaires, which are used often by 501c groups, C4s, and trade associations, may also be used by 501c3s. Again, the approach is that your questionnaire should be sent to all candidates for the office. There should be an unbiased sort of structure to the questions, and in terms of content, you want to cover all major areas of interest, give candidates a reasonable opportunity to respond. Again, the questionnaire, just like the forum, should not ask a candidate to sign a code or a pledge to agree that they favor a particular position, because that could be viewed as demonstrating some favor or disfavor from a particular candidate. The overarching rules are really not that hard. You may find in the execution that you've got a question or two or three that you want to give a little bit closer scrutiny, but by and large, if you stick to being nonpartisan and neutral and fair, you're going to be okay. So scorecards, which are often referred to as legislative scorecards, more or less a compilation of the votes that members have taken, are also something that 501c3 groups are permitted to do. Again, to avoid the implication or appearance that you're doing this to try to help or harm a particular candidate, it's important that this be something that you do regularly, that's synced up, that coincides with the end of the session, for example, rather than timing the release a month before the election, that you include a variety of issues, that all legislators are included, not just the legislators who might be running for office that year. So if you're doing the Senate, it would have to be all the members of the Senate, and no editorializing. So the kinds of things that a 501c4 group might be able to do, where you see the side-by-side comparisons with the thumbs up perhaps or the thumbs down, that's not something that the C3 can do, again, because it suggests approval or disapproval of particular positions.
Larry, before you move on, there was a request for clarification from a prior slide regarding candidate forums and debates. She said, at the federal level, you said that you cannot have an empty chair debate, but you can have two separate forums for the candidates where they appear at different times. Can you clarify that?
Right. So if your event is styled as a debate, you're inviting candidates who are running for House, for the same House seat or for the same Senate seat, and you've got a Republican and a Democrat, and you invite the Democrat to the debate, and the Democrat doesn't appear but the Republican does, the FEC would say that that kind of debate, if it's presented by a corporation or a nonprofit in this case, could be considered an in-kind contribution to the candidate who appeared, because you styled it as a debate, but you're really only giving one person an opportunity to talk. The forum is different because you've got a serial appearances before your audience, and you're not presenting it as a debate between the two or three candidates for a particular office.
And the FEC rules do make sort of the forum tricky. I think we've talked to a number of clients who, it happens all the time. Candidates address membership groups, different kind of events. But at the federal level, the rules really contemplate either that you're limited to your membership, because there's different rules when you're talking to just your members, or that it's that everyone's on the stage at once. There is a bit of a gap, I think, in the sort of federal rules that sort of specifically say how you could do a forum like that where they're not on stage at the same time. So it does get to be very tricky. And
while we wait for Mike there, what you just answered was under federal election law. And when you put the overlay of the 501c3 rules for these sorts of forums, how does that alter that answer?
I think so the way that I look at it is, if you think about start with the campaign finance rules. So if you're at the federal level, think about the federal campaign finance rules, and then if you're at the state candidates, think about the state rules. Figure out how those apply, and then apply the C3 layer to it. So, or vice versa, whichever way you want to think about it. But at the C3 level, you need to invite everyone. You need to have a neutral atmosphere and ask neutral questions and make it fair and balanced. At the federal level, if it's a federal candidate, you've got to think about whether the rules prohibit the empty chair debate. So you can't do an empty chair federal debate because you're going to violate the Federal Election Campaign Act. At the state level, they might not have that distinction, so you could have one candidate that shows up if you invite them all. So that's, I think, the way to distinguish that.
Yeah, and I wanted you to answer that as well, because it's a great illustration of how a lot of people, when they're analyzing questions and issues in this area, focus only on one of those sets of rules and forget the other. And it really is critical to think about all of the applicable rules. So we have a question right here.
No question about surrogates. So, imagine a situation in which you have both campaigns, and that obviously, if it's presidential, for example, you're not going to necessarily get the candidates themselves, but they'll send a surrogate. So a situation in which one campaign sends a very high-level surrogate and the other sends a very low-level surrogate. Could there be an appearance of bias in that one person just speaks with that much more authority on behalf of their candidate and the other is just kind of lower level in that sense?
Yeah, I think the key there is that your invitation extends to people at the same level in each campaign. I think if you've got representatives there of both campaigns, it's unlikely that that's going to be considered favoring or disfavoring, so long as you've made the opportunity equal and the representatives are there. You've left it to the campaign. If the campaign's decided to send a lower level surrogate, that doesn't transform the event into a partisan event. Same view on that?
Yeah, I agree.
So voter registration can also be a little bit tricky. Again, you've got this basic guideline that the voter registration needs to be nonpartisan. That doesn't mean that you can't target certain interests or certain people with common interests or certain groups. So it's common, for instance, that 501c3 groups will, for instance, target Hispanic communities to register, or target communities by race, by gender, even by economic status. It's appropriate to send people to college campuses if the focus of your organization is to register students. The critical piece here is really that whatever you're doing, however you're targeting the group that you're attempting to register, there has to be a charitable purpose for doing it. So what you can't do, and this comes up often when our clients want to target certain geographic areas, is what they're really after is trying to register more conservatives or more Democrats or more people who are likely sympathetic to environmental issues or gun issues or whatever the organization happens to be about. And if you're focusing your efforts in that manner to register more people who are likely to be sympathetic to your agenda, then you're more likely to get into trouble with the IRS. You want to make sure that whatever you're doing in regard to voter registration is consistent with your charitable purpose and without regard to any electoral objective.
So in addition to sort of these different kinds of events, there's a number of other ways to interact with candidates, and that 501c3s want to sort of get candidates involved in the issues. And so one area that comes up a lot of times that is permissible is you're allowed to lobby candidates, and you can send materials to candidates and say, hey, we hope you'll agree with us on this issue. We support X, Y, Z. We hope it'll be an important part of your platform. You're allowed to do that. It's not considered to be lobbying because they're not covered officials with the campaign. But when you're doing that, you can't ask the candidates to take a pledge because, again, this is the distinction between sort of endorsing a candidate, which would be say, hey, this candidate signed our pledge, as opposed to urging a candidate to support particular issues. If you're preparing sort of talking papers or issue briefs, you should provide those to all candidates and not just to one candidate. I get this question a lot where, hey, the candidate X called us up to say that they would like some more information on this issue. Can we provide it to them? And the answer is if it's already prepared, if it's your standard issue brief, then sure, you can give that to the candidate. You might think about emailing it out to the other candidate or someone you know from the other campaign to make sure you're being neutral there, or that it's available on the website. But what you generally shouldn't do is create content at the request of a candidate from the organization. So if they call up and say, hey, I know you guys support this particular issue, can you put together some facts for me about this? You could point the candidate to the already existing materials, but if you prepare the fact sheet for that candidate with statistics, that would be providing something of value to that campaign, which would be campaign intervention, and also an in-kind contribution under the federal election law. So you want to be careful with what you're providing, so use off-the-shelf materials, or if you do create something to interact with the candidate, for the purposes of influencing candidates, that you provide it to all the candidates and not just to one or another.
We were asked recently by an organization whether they could provide talking points to all the candidates who were running at the time in the Republican primary as a way of encouraging them to talk about a certain issue in what the organization believed was a less inflammatory way. And our advice ultimately was that it was appropriate to have those meetings, and it was even okay to provide the talking points so long as the meetings were held, as Ron said, across the board with all the major candidates who were running for the Republican primary presidential office at that time.
And now we're going to shift a little bit from sort of the interaction with the candidates to sort of your messaging that you may be sending, the messages you may be sending out around election time. And the way I kind of look at it is there are sort of three buckets of communications, and I have the arrows between them because they really flow into one another, and really small changes can move the communication from one bucket to the other. So
and Ron, just to clarify, we're still talking about 501c3
yes,
organizations.
on 501c3s.
Keep that in mind.
So the kind of three buckets, one bucket is lobbying, another bucket is issue advocacy, and the third bucket is campaign intervention. And obviously we've kind of laid this out. Lobbying is allowed up to a certain limit. Campaign intervention is prohibited, but issue advocacy is okay. And so as you go through there, the IRS says we use a facts and circumstances test to figure this out. We look at issues such as timing and the content in what it says. So you may have communication that you've designed as a lobbying communication that you would send out in the middle of a legislative session. That's fine. But if you send that same communication out right before an election where you're really criticizing a candidate, the IRS would say that that's more likely to be campaign intervention. So this is one of the gray areas, I think, and you want to be very careful anytime you mention a candidate or a political party or sort of an issue position near an election. You want to think carefully and make sure you've got it in the right bucket so that you don't go into the wrong category. One of the things that I think is tricky with the IRS in its view of campaign intervention is that it is a very broad construct. So this diagram is designed to show that there's a concept in the federal election campaign laws of express advocacy, where if you have a communication that says vote for Larry Norton or vote against Jeff Tenenbaum, that's express advocacy, and it's a fairly constrained universe. There's regulations that go around that, but those generally you have to have sort of the clear words, or there has to be no other interpretation that you're supporting or opposing a candidate. The IRS has a different view. So any express advocacy is going to be campaign intervention necessarily, but there's a lot of other communications that might not meet that express advocacy test that still are considered to be campaign intervention, and even can touch on, as I said, some of that issue advocacy material that is not designed to really, it doesn't see, at first blush it's written to influence issues, but may talk about candidates in a way that the IRS would say that it actually is campaign intervention. So the last little bucket that we want to kind of talk about on the C3 world are sort of executives, because your C3, as we've said, is not allowed to engage in a campaign intervention and political activity. But the question then becomes, well, what about our executives or our employees? Are they allowed to engage in activity? And the answer is yes, they can. They don't lose their First Amendment rights to participate in the process just because they happen to work for a C3, but you have to be careful. You have to make sure they're acting in their personal capacity, not as the CEO of the organization, but as Joe Blow off the street. Now you can use their position for identification purposes. I'm going to give some examples of that in a second, but it has to be clear that it's really just to identify the person so you know who they are. They can't use the 501c3 resources to do their work. So if they want to send out a fundraising letter or a letter to support someone, they can't use the mailing list of the C3's members. They have to use their own personal contacts to do that. They're allowed to serve in an advisory capacity. So a lot of times it's a tangential to your surrogate question. But what if the surrogate is a high-level 501c3 official? The answer is they're allowed to do that as long as they're doing it in their personal capacity and they're not using C3 resources. So you might think if you have sort of a politically active group of executives, make sure you have a policy in place that sort of clearly distinguishes when they're acting in their personal capacity from their official capacity. And as I said, you can use their position for identification purposes, but you need to make sure you've got the disclaimers on there. So let's say your executive director does an op-ed in the newspaper, and they're identified as the executive director of the particular 501c3. That's fine, but you want to make sure that when the newspaper prints it, ask them to include that the views are that person's views and not those of the organization. That it's just provided for identification purposes. An example of a fundraising letter there, the titles are provided for identification purposes only, or if a C3 official is going to be on a TV ad, again you can include explain who they are, but make sure it's clear that they're in their personal capacity. A lot of times C3 executives will be involved in fundraising. Again, kind of the keys here are not to use the facilities of the C3, the email lists, or the C3 space. Use your personal contact lists. Be careful about that. Just kind of another one of these where the election law overlaps. If you probably have told your executive, don't do fundraising at the C3 office, host the event at your home. Under the Federal Election Commission rules, you can spend up to $1,000 on food and invitations before it's considered to be a contribution to the candidate. So what person has $1,000, their spouse has another $1,000. Anything above that gets counted as a contribution to the candidate. But basically, if you two people would have $2,000 worth of food and beverage, they could provide. The state rules vary widely on that, and of course, the candidate can always pay for their the food and beverage. And if we have a question.
Yes. Why can't the in-home contribution be $2,700, the maximum given for each per election?
Sure. So the question is, why can't an in-home fundraiser be $2,700? And it can. It can actually be $3,700. So there's a first $1,000 is exempted from the definition of a contribution period. So if you donate $1,000 worth of food, that doesn't count as a contribution. You could then go on top of that with $2,700 worth of food, which would be the in-kind contribution. If you keep it below the $1,000, you could write a check for the $2,700, and it doesn't count toward that. But if you were to give $2,000 worth of food, you could then only write a $700 check to the candidate, for example. It's a very good question.
Ron, before we move on, we have a question from the webinar. In an election year, can a 501c3 organization make seats at a gala or other event, presuming it's the nonprofit's gala, free to a single candidate because that candidate has supported the cause for which the 501c3 advocates?
I would not do that. I think that's you're favoring one candidate over the other. Now, I think that's an example of where you have to think about what the person's capacity is. So, is that a mayor running for Congress? Can you invite the person as the mayor? Absolutely, I think you could do that, and make clear that you're inviting the person as the mayor. If it's if the person doesn't have some other position and you're inviting them as the candidate for city council or candidate for mayor or candidate for Congress, that I would avoid doing that. I think that presents some problems. So now we'll flip over and talk about C3 and C6 organizations. Maybe we should ask if anyone has any other questions on the 501c3 aspects of things before we kind of switch over to the other area.
We have a question right here.
This may be a general question applicable to C4s and C6s as well, but practically speaking, how could you get in trouble? Where would, if an investigation into your activities were because these regulatory agencies initiate it, or is it because somebody, from the political party or a candidate files a complaint, or could it be either?
All of the above. It depends what kind of organization you are and what you're doing. If you're a 501c3 organization and you're engaged in what the IRS believes is political activity defined as supporting or opposing a particular candidate, you're jeopardizing your tax status, and that could generate negative publicity. Investigation could come up in the context of an audit and so on. If you are providing, whether you're a C3 or another organization, and you are providing a benefit to a particular candidate through a forum or through an event or through an invitation, that could be considered an in-kind contribution and might provoke a complaint with the state election board or with the Federal Election Commission. And sometimes we are assisting our candidates on multiple fronts because, as Jeff said, multiple agencies, federal and state, can have a stake in the same conduct.
And just keep in mind one clarification to that. A lot of this comes to light and gets the attention of federal or state regulatory authorities through publicity, through complaints from adversaries, causes issues upon political opponents on the other side of the aisle. That's what often triggers these things. But in all of these instances, it's only the federal regulatory agencies themselves that can do something about it. There's no, what lawyers call a private right of action. There's no ability to file a private lawsuit against a party alleging some noncompliance with the IRS rules or FEC rules or something like that. But it is very common for complaints and publicity and referrals from state attorneys general and many other places to cause the IRS to open an audit, technically called an examination, or the FEC to open an investigation and or take some enforcement action. But they have to go through that process in order for something bad to happen as a result. It cannot happen otherwise. Yeah, question there?
Yes. This I preface it by saying this question could be for C3, C4, or C6. Let's say an organization wants to do a poll on issues relevant to the candidate involved. If they do the poll, after a certain period of time, I understand, that poll can be given to the candidates. If that's the case, is it 30, 60, or 90 days after the poll is done?
This is where you get into the variations between state law and federal law, and frankly, between and among states. We were looking recently at a state where the law was structured just the way you describe it, where the value of the poll diminished. The law says that after 30 days, it's only worth 50% of what you spent for it, and after 90 days, it's worth 25%, and after 6 months, it's worth nothing, and you can give it to the candidate. There are other states and under federal law where that same rule doesn't apply, where the poll is valued at whatever it is that you spent for the poll, but there may be other ways you could share the poll with a candidate. So, for instance, under the Federal Election Commission rules, if you have made the poll results publicly available, that doesn't mean every page of the poll that you receive, but you've summarized them in some fair fashion and put them up on your website, then it has no special value to the candidate who you meet with to discuss it and share it, even if you're sharing a lot more detail in the poll than you made previously public. And the FEC, the Federal Election Commission, would say that's not an in-kind contribution to the candidate. So it really depends on who the candidate is and what jurisdiction you're talking about as to whether you can provide poll results.
I'm thinking federal.
I don't recall that the Federal Election Commission rules provide that the kind of sliding scale. I've seen that as a matter of state law. Under the federal rules, if you're sharing the poll results with a candidate and you haven't made it publicly available, then it's going to be considered an in-kind contribution, I think, to that candidate.
Okay, thanks. Move on to the next section.
So we've wrapped up 501c3s, and we're going to move over to 501c4 and 501c6s, each of which may engage in the kind of partisan electoral activity that a 501c3 cannot. They are permitted to support or oppose candidates subject to certain limits. The 501c4 I often think of as the sort of all-terrain vehicle of nonprofits. It can do educational programs like 501c3s can do. It's entitled to engage in unlimited lobbying, and it's entitled to do partisan electoral activity so long as it's not its primary purpose. Let's talk a little bit about where the limits are on electoral activity, partisan electoral activity by 501c4s and 501c6s. Again, going back to Ron's point very early on in our presentation, incorporated nonprofits, just like for-profit corporations, may not make contributions to federal candidates. They may only make independent expenditures. So no direct contributions and no in-kind contributions. State law varies considerably. Some states do permit contributions by nonprofit C4s and C6s to candidates, but impose limits. In some cases, those limits are the same as apply to for-profit corporations. In some instances, they're not, where they may depend on the structure of the nonprofit, the corporate structure. And as a matter of tax law, as I said a moment ago, 501c4 or 501c6 is not cannot use its funds for partisan political activity if that partisan activity is its primary purpose. We'll talk in a moment about what that means.
And just keep in mind, it's always important to remember distinctions here. Partisan political activity, like supporting or opposing candidates for public office, that's where there is that kind of 51% limitation on C4s, for instance. But in the lobbying area, when we're talking about kind of supporting or opposing legislation, pending or proposed legislation, that's a very different and distinct area, and under federal tax law, that is not at all limited for C4s or C6s. So long as it's in furtherance of the purposes of the organization, you can engage in unlimited lobbying. That's obviously in contrast to the 501c3s, where lobbying, legislative lobbying, is permitted, but it is limited. The scope of all of those rules are beyond the scope of today's presentation. But if you're interested in that, we have done prior webinars on that topic where we got into great detail on that, and we have recordings of those on our site.
And again, back to ballot initiatives and referenda, which are very hot and popular right now. The IRS perspective on ballot initiatives is that it's lobbying, that you're asking people to vote on a law, and if the referendum passes, the law passes. And so while it feels electoral, and while under state law it's regulated as election activity and requires registration and reporting as a political committee, in the view of the IRS, that's legislative activity that can be conducted without limit. On the other hand, if what you're talking about are supporting or opposing candidates, that kind of activity, election-related, that support or opposition of candidates, can't be the primary purpose. For a long time, and I think this is still probably generally true, is that the thought is that what that means is that partisan political activity shouldn't be more than 49%, shouldn't be more than 50% of your activity. There's no IRS regulation that spells out 51% or 49%, but it's been the rule of thumb for a long time. In the wake of the scandals and hearings of the last couple of years over the IRS treatment of 501c4 applications, the IRS has attempted to provide some clarification and created an expedited process for reviewing applications for recognition of tax-exempt status by 501c4s. And the IRS said, well, we're going to create a safe harbor for 501c4 or 501c6 if no more than 40% of your activity is involved in supporting or opposing candidates. We will expedite approval of those applications if no more than 40% of what you're doing is election-related activity. 60% though of your activity has to be related to so-called social welfare activity that is not political in nature, and that means 60% or more of your total expenditures, including overhead, and your total time, which is supposed to include employee hours plus volunteer hours, which can be obviously a complicated calculation for a group that depends pretty heavily on volunteers. But this is really how this slide demonstrates really what kind of activity in the IRS view falls in the social welfare category, education, coalitions, lobbying, and what falls in the political side, which are contributions to candidates and independent expenditures. And you see a similar breakdown for trade and professional associations, education, training, regulatory work, lobbying. Anything that improves the business line is considered to be within the primary purpose, but you cannot spend more than half of your funds on independent expenditures or contributions.
Before you move on, Larry, we have a great question from one of our participants on the webinar. Bit of a loaded question, but I'm curious how Karl Rove could secure 501c4 tax-exempt status for his Crossroads PAC.
Well, Ron and I were actually just talking this morning about the challenge of advising clients who will call us with some version of this question, which is, yeah, we hear you on this 51% to 49%, but there's this organization out there, whether it's Rove or it's a C4 that was supporting Marco Rubio or some other organization, that appears to be doing nothing but supporting or opposing candidates.
Wait, before you answer, I should clarify. The question said PAC, but we're not talking about a PAC, obviously. We're talking about a 501c4.
Yeah, I think that's one of the other things that is also complicated in this area is that particularly the Crossroads that was being discussed, there was a C4 and then there was also a Super PAC there. So they both, one was Crossroads and Crossroads GPS. So it's important to really understand the structures because I think people do have very similarly named entities. One can be a C4 or a C6 and a Super PAC or traditional PAC. So part of that is understanding which is which, and that's important, a distinction to draw.
Right. And the issue for 501c4s, like that group that the person who asked the question was asking about and some of these other C4s, is that technically speaking, under the Federal Election Commission rules, if your major purpose, which is similar to the IRS's primary purpose, is influencing federal elections, you're supposed to be registered and reporting as a federal political committee, which means you're also subject to those contribution limits that Ron talked about at the outset of the presentation, and you shouldn't be able to accept unlimited contributions as 501c4s can do. The area is extraordinarily murky right now, and the murkiness comes, frankly, from paralysis in enforcement, the fallout, I think, of the controversy over IRS targeting of conservative 501c4 groups, and that, for the time being, I think what we would say to our client is, if you want to do political activity, you want to do a substantial amount of political activity, you want to do some lobbying and grassroots, maybe you want to do some education, there's a way to structure yourself safely that may involve more than one organization that can work in tandem, a 501c3 with a 501c4, or a 501c6 and a Super PAC, and accomplish whatever your objectives are without very significant risk. These organizations that are pushing the envelope are probably not taking a lot of risk at the moment, but at some point the rubber band will snap back, and you're seeing it more on the state level where they're pursuing C4s that are really operating as for all intents and purposes, as political committees. Again, the IRS view of campaign intervention, what is the activity that you can't do more than half of, and that's, the IRS says that comes down to a facts and circumstances test, which is not very helpful in some cases, that looks at the timing of your activity and the content and the context. The IRS has attempted through rulemaking, has been attempting through rulemaking to define better what campaign intervention is, what kinds of activity a C4 cannot engage in as its primary purpose. But unfortunately or fortunately, however you come down on it, Congress stepped in December of last year and stuck a rider onto a spending bill that prohibited the IRS from spending any money during the fiscal year to continue working on this rulemaking or providing any more guidance on what constitutes appropriate activity for a 501c4. And the effect of that action by Congress is basically to freeze up all of the IRS work in attempting to clarify, not just for C4s, but for other organizations, what kind of political activity is appropriate. And so, you know, it remains the law really, the available authority really has not changed significantly in decades.
It actually, the Congress managed to even get that wrong when they put the rider in place. It prohibited them from spending money to release the rule. So theoretically, the IRS could be working on a new rule right now, and when October 1st comes along, they could issue the rule. There's some speculation that could be happening, but it's you know, certainly that would not, I think, would not take effect, you know, on October 1st for the November elections. It would probably be a year out beyond that. But leave it to Congress to not even figure out how to tell the IRS not to spend money on something to accomplish what they wanted to accomplish.
I think the safe assumption at this point, and we've got those 4 items listed under intervention, those 4 things, express advocacy, contributions, endorsements, support for a connected PAC, all of that, regardless of what the IRS does in the way of clarifying rules, has been and will remain, in the view of the IRS, activity that's considered political activity, support or opposition for candidates.
And Larry and Ron, just to make sure everyone's on the same page, so the primary benefits of, say, Crossroads in going the 501c4 route and taking a position that they're not covered by the Federal Election Campaign Act, primary benefits are what?
2 benefits. One is that C4s that are not registered as political committees are entitled to accept unlimited contributions and contributions from any source. So while a federal political committee can't accept corporate money, can only accept $2,700 per individual, a C4 can accept an unlimited amount of money from individuals, and it can accept contributions from corporations. The other major benefit for 501c4 is reporting. So the donors to 501c4s are not publicly reported as donors to PACs and political committees are under either federal law or state law. So for organizations that want to try to raise money from donors who really don't want to be publicly identified, the C4 can be a very attractive vehicle to use for their partisan political activity.
Yeah, and we'll talk about the other Super PACs, which in those examples, you know, that's the other one where Super PACs can accept corporate money and unlimited money in a way that a traditional PAC can't, but they are disclosed, and so that's the other, you know, that disclosure piece really becomes, I think, in many ways the driver of why you try and shoehorn political activity into a 501c4. So we've made reference to the fact that the federal law prohibits corporate contributions, direct money to candidates, and that some states allow it. This slide just gives sort of a very high-level overview of sort of the idea that in some states corporations are allowed to give. In some states they can give unlimited amounts of money to candidates. So, you know, Virginia is a good example where it's unlimited corporate contributions. So there, if you can coordinate with the candidate. You can sit down and say to the candidate, hey, what do you need? Can I give you these computers? Can I buy this airtime for you? And it's a corporate contribution, which is permissible, whereas in other states where it's prohibited, you wouldn't be allowed to have that coordination. You wouldn't be allowed to write the check. And then the sort of the orangish or yellow states, their contributions are permitted, but they're limited. Some of them have very low limits. Others have fairly high limits. It kind of depends widely, but this is just kind of give you a sense that it really is literally all over the map of what's permitted in different places. And then the next piece to talk about are independent expenditures, and we've kind of talked a little bit about this, but again, just kind of get a sense of what these are. They are communications that either support or oppose candidates. They can be on your television, radio, web, email, get out the vote activity. A lot of independent expenditure activity lately has been in the sort of identifying voters, going door to door, paying for those kind of things, as opposed to just the big TV ad buys that we've seen in prior years. But the key for an independent expenditure is that it's not coordinated with the candidate. It can't be done at the request or the suggestion of the candidate. So there's a couple of different ways that something is coordinated. And we're not going to, the FEC's rules that I always blame Larry for because he was the general counsel when they wrote the coordination rules, they take up about 4 pages of tiny print to try and define what coordination is. But this is just kind of to give you a good sense of kind of the key areas where coordination comes into play. Again, it's the request of a candidate. Hey, I'd really like you to do to do a commercial or do a mailing to your members that talks about X, Y, or Z. It's the suggestion by the person who's going to spend the money. So, gee, Congressman, we're really thinking about going on the air with an ad that talks about your support of education initiatives. And if the congressman or the candidate either assents to that or accepts that suggestion, then it's considered to be coordinated. So it's a good example of why you may not want to, it's a good idea not to talk to a member of Congress even if about any of the electoral work you're going to do. Try and keep that very separate so you don't get their assent accidentally if you're telling them about what they do. One of the things with independent expenditure activity at the federal level in most states is that it's very well disclosed. So you don't have to have the conversation with the congressman to know that it's happening. He or she will know that it happened after it was done and see who paid for it. So it's you don't have the conversation. The coordination rules talk about substantial discussion. So if you have, I've always kind of wondered, Larry, how you manage to get request or suggestion without a substantial discussion, but or substantial discussion without one of those other two. But if you're talking about sort of what are the key demographics, what are the timing that you want to do on your ads, when you're talking about those kind of things, then that would be coordinated. And then the other two are sort of particular ways that you do engage in the activity. One is a common vendor. So imagine that your 501c6 wants to do independent expenditures to support a candidate, and you hire a media company that also works for the campaign. That would be coordination because there's a presumption there that the media company knows exactly what the candidate needs when you hire them to do the media work. So what the FEC says is that you have to have a firewall in place. So if you hire company XYZ to do the work, partner 1 can do work for the candidate while partner 2 does work for the independent expenditure group. They have to have a firewall in place so that they don't talk to one another. I had a client once where one of the consultants had a small consulting shop, and the Super PAC that was working for that candidate hired the same consultant, and unfortunately in the newspaper they showed a picture of their office, which was about the size of this table here. So there's a good question as to how effective the firewall could possibly be, but they had the procedures in place to do it. And the other piece that comes into play, and this gets back to the question about sort of the timing of the poll, I think, former employees are prohibited from switching from the campaign to the Super PAC for 120 days after there's to be a 120-day cooling off period. So it's similar to that concept with the poll, but basically any information the employee has in his or her head sort of loses that value over that 4-month cooling off period, so that you get to the point where you're not sort of sharing inside information between them. Now you can theoretically have an employee to switch as long as they don't use any non-public material information, but it's kind of hard to see how an employee at a sufficient level of the campaign would ever be able to sort of meet that test without waiting for the cooling off period.
Yeah, we'll frequently suggest that our 501c4 clients or C6 clients have a firewall of their own, so that employees who are working on the independent expenditure campaign are not the same employees who are interacting frequently with members of Congress over other initiatives or state legislators. So there's some assurance that the organization doesn't trip over the coordination rules, and some defense if a regulator comes knocking that you've taken appropriate precautions to ensure that the content of your outreach, your GOTV, your television ad, your radio ad, whatever it is, your content, your timing, your audience wasn't influenced by information that was obtained from a candidate or a campaign representative.
So now we've covered the C3 landscape, we've covered the C4 and C6 landscape. Now we want to talk about political action committees, which are something that C4s and C6s can have. C3s are not allowed to have their own political action committee. They can. So let's kind of talk about sort of what is a political action committee. So at its heart, it's a separate segregated fund, a separate bank account that doesn't contain any corporate money. That's kind of the key, is that it has to be made up of individual contributions from U.S. citizens or permanent residents that are voluntarily given, subject to the limits of $5,000 per year, and then you use that money generally to make contributions to candidates of up to $5,000 per election to the candidate. You can also use a PAC to make independent expenditures. Since the Citizens United decision and corporations being allowed to do it directly, typically in the association context, you would see the association funding the independent expenditure with its corporate money, but you can certainly do it out of a political action committee as well. Just a couple of sort of myths. A lot of people talk about PACs as sort of the evil Washington insider kind of thing, but some of the bullets that I usually talk to clients about is that PAC doesn't buy influence. There are PACs on all sides of an issue. PACs are limited to $5,000. So when you think about a typical congressional campaign that costs close to $1 million and a Senate campaign that costs over $2 million, that's a lot of different PAC contributions coming in. So that it's hard to to say that it's that PAC contribution that made the difference. PACs are also highly transparent. Contributions in and contributions out are disclosed, so it's an easy way to see sort of what's going on. PACs do provide an opportunity to interact with lawmakers, so you get a good sense. You can attend a fundraiser with a PAC contribution in a way that you might not be able to have the ability to interact with that member of Congress. So that's one of the advantages, but they don't buy the influence. And then the key is that really why do you have a PAC? It's to help elect and retain members who understand and support the PAC's positions. So you're giving to candidates that you think will be receptive to your views, have been supportive in the past, not as a particular quid pro quo for any kind of particular vote, but just basically we want more candidates like this person. We think this person's a great member of Congress because they understand our issues and are going to be helpful to us.
And just to interrupt for a second on the subject of myths, in your articles in the handout materials, there's one of my favorite articles that Ron and I wrote a few years ago called Myths About Lobbying, Political Activity, and Tax-Exempt Status, that dispels a whole bunch of myths about all of the rules governing lobbying and political activity and federal tax-exempt status. And for those of your organizations who are resistant to engaging in certain lobbying and or political activity because they're worried about violating some federal or state campaign rules or tax rules or whatnot, that article should be particularly helpful to you. And there's also a brand new article, Ron and Larry haven't gotten to the subject yet of Super PACs, but there's a brand new white paper that they just finalized yesterday called Setting Up and Operating a Federal Super PAC, which I think is a great overview of these issues for those of you who want more detail.
So two kinds of PACs. You may hear the term connected or non-connected. I'd venture a guess that for those of you who work with trade associations and have PACs, those are probably connected PACs. The advantage of a so-called connected PAC is that it bears the name of the association. It's the only way, in fact, you can make a contribution to a member of Congress that bears the name of your organization. And the other major advantage of a connected PAC is that the association itself, the so-called connected organization, can pay all the costs for running the PAC and for fundraising the PAC. All the compliance costs, all the costs to lawyers like me and Ron to provide you advice and to assist you with your reporting, all of that can come out of the budget of your organization and not out of your PAC. And what we like to say to our corporate clients and trade association clients is the greatest selling point for your PAC, for your connected PAC, is that every dollar that's raised is going to be used to make contributions to candidates. None of it needs to be used for overhead costs. The downside of a connected PAC is that you can only solicit the so-called restricted class, or for purposes of trade associations, the restricted class of your corporate members, and we'll talk in just a second about who those are. The other kind of PAC is the non-connected PAC, which doesn't have this sponsoring corporation that bears its expenses. It can use any name that it wants. It can solicit anybody in the United States other than a foreign national. Why not just have a non-connected PAC? The reason is that all the expenses, your compliance costs, your legal fees, your bank fees, and accounting costs all have to be paid for by the PAC. They can't be borne by another organization. We have a question.
Thank you. Can a connected, separate, segregated fund publicize endorsements of federal candidates to the world at large, or is it only to your membership class?
Such a good question, because the Federal Election Commission, which seems to be in no hurry to revise some of its regulations post-Citizens United, still has a regulation in the books that technically remains in effect that very much constrains how a corporate entity or an incorporated nonprofit can endorse a candidate. Essentially, it says you can do it only through a press release. The press release has to go to your usual media outlets, and apart from that, you can't do anything. Well, we all know after Citizens United that, in fact, corporations are permitted to speak freely and endorse candidates and support candidates so long as they don't coordinate with candidates. And so I think that rule, although it hasn't been technically superseded, is a nullity. And there's really nothing at this point that would prevent a corporation from endorsing a candidate so long as it's not coordinated with the candidate. And so, you need to be careful about the staging of an event, how much involvement the candidates or candidate's office has in your release that you describe your endorsement. All those kinds of things could make it coordinated. But so long as it's independent, I think it's safe to say that there's no risk in doing that for a 501c6 or C4.
On the connected versus non-connected concept as well, I think one of the things to keep in mind that if you do a non-connected PAC, I have a number of people have said, hey, gee, we've got a 501c3, we can't do a connected PAC, so let's do a non-connected PAC. And that sounds great and can work, but you have to be careful not to use any of the C3 resources for that PAC. So how are we going to email the membership of the C3 to solicit contributions for the PAC? Well, the PAC's going to have to buy the membership list from the C3 organization. There's, or we're going to have to come up with a different source for it. So you've got to be very careful if you do go that non-connected route that you really aren't using corporate resources from an organization that is there sort of lurking in the background for a PAC.
These next few slides focus on the connected PAC, and for those of you who work for trade associations, have a connected PAC, you're familiar with these rules that you can only solicit contributions from members of your restricted class. And the way the Federal Election Commission rules define the restricted class differs depending on whether you're a for-profit organization, a membership organization, or whether the sponsoring organization is a trade association.
And we should clarify, by trade association, we probably should have said trade or professional association. And as Larry's going to explain, the rules are a bit different in terms of solicitation restrictions on whether it's a trade association where the members are companies or entities compared to professional association where the members are individuals.
Right. No, good point. So very quickly, the corporation's restricted class, by and large, these are going to be the salaried executives and policymakers for the organization. Those employees who by and large are exempt from the overtime rules under the Fair Labor Standards Act, board of directors who receive some payment for serving as members of the board, members of the FEC's rules say members of the recognized professions, so lawyers, accountants, engineers, and so on are going to be included, and family members, which means members of the immediate families of shareholders, lawyers, salaried executives who live in the same, members of the immediate family who live in the same residence as those individuals. All of those people may be asked to make contributions to a corporate PAC. Membership organization restricted class works similarly, although here the big distinction is that you have individual members of the organization who can be solicited under the FEC rules for PAC contributions if they actually meet the requirements that the organization has for becoming a member, and they pay dues at least annually, or they have some other governance, some right to participate in governance, normally voting. Those kinds of individuals can be asked for PAC contributions, and again, salaried executives and professionals who work for the organization can be asked for PAC contributions.
And this is where Jeff's comment that there's a distinction between trade and professional associations. The professional associations where the members are the individuals, the doctors, the lawyers, whatever, that works in the individual membership category as opposed to the trade association rule where it's a corporate member in the organization that Larry's going to talk about now.
Well, right, and that's really the last category of corporate membership in trade associations. And there's a process that Ron will talk about in a moment where once you receive prior approval from your corporate members, you can solicit its executives, its salaried executives, its lawyers and accountants and engineers and so on for purposes of making contributions to the trade association PAC.
So with that concept in mind, we turn to prior approval, which for those of you who have a PAC and have corporate members, you know this is probably the most annoying rule that you deal with, the one that probably restricts or hinders your ability to raise money for your PAC more than just about any other campaign finance rule out there. The rule basically says that, that you're allowed to solicit the executives of your member companies if the member company gives you prior written approval. A couple of caveats to that. One is that the company may only approve one association per year with prior approval. So if you're a member of if a company is a member of 2 associations, they can only give approval to one of those associations. Now it applies to the specific company that's a member, not to parents or subsidiaries. So if you've got a parent company that's not a member of the association, that parent company can give approval for its restricted class to a different association. It must be in writing. One of the things that sometimes helps is to have the company, you can let the company limit the scope. So there's, I think, generally a feeling when you send this prior approval form to the companies, they think, gee, what in the world am I signing away? My employees are going to be bombarded with communications from the association. So what you can do is say, you know what, here's the 10 people that I want you to solicit for our PAC, or for your PAC. Only those 10, you can't talk to anyone else, or here's the 5, or you could design it so that you say, send me the solicitation materials and we'll solicit the executives so that the association's not doing so. But there's a variety of ways like that to try and get sort of a better response. Now one thing that you can do when you send the prior approval material is you can include a sample solicitation. So typically you'll say, hey, person who's active in the association, we'd like to solicit you and your fellow executives at your company who are interested for our PAC. Here's the prior approval form we need you to fill out, and you'll see a sample of the kind of materials that we would send to you if you provide that prior approval. So what that does is that it really limits your ability to communicate with your corporate members. Your requests, until you have that prior approval, all of your requests have to be focused on asking for prior approval. They can't ask for contributions. So that really, it presents a hurdle. So what happens then when you send a prior approval response? I think this is important for everyone to kind of understand, is that there's I see it as sort of 3 things that can happen, or I guess a 4th would be nothing and you don't get any response. But the first would be the ideal, which is that the member company signs the form, sends it back, and then you add those people, you start soliciting their executives for contributions to the PAC. But the rule really applies to, it limits the association in how it solicits. It doesn't prohibit receipt. So if you send the prior approval form with that sample response, the response may be, no, we won't give you prior approval. We've got our own PAC, or we've got a policy against doing prior approval, or we've given someone else prior approval, but here's my personal check for $5,000 or $1,000 or $100 for the PAC. So you can respond if so you don't have to have the prior approval if the person responds to the request for prior approval with a check. You can also, and this happens a lot of times, is that the member company may say, no, we won't give you prior approval. We have our own PAC. We don't want anyone else soliciting, but here's a PAC check from our PAC to your association PAC. Those are all permissible responses. You're not allowed to ask for those individual contributions. You're not allowed to ask for that PAC contribution. But when you ask for their prior approval, that can be the response back. So what are some ways to deal with this? What I've seen a number of people doing is looking more and more toward creating individual membership. If you look at the professional associations that have individual members, they really tend to have a much greater success with their PACs than the trade associations that have corporate members and go through prior approval. So we're seeing more and more sort of an effort to create individual members to have them either pay dues or have a role in the governance, so that you can solicit them directly. And that's, I think, something that more and more organizations are doing, and we'll see even more of in the future.
We're running a little bit behind schedule. I'm going to move through this section quickly. PACs, sponsoring organizations to PACs and PACs themselves may offer incentives to try to encourage individuals to contribute to the PAC. We have examples here of trinkets and prizes and charitable matches. The important thing to remember, and we have a couple of examples in the following slide, is that if you're having a fundraising promotion for the PAC, the value of any prize you provide can't be any more than 1/3 of the amount of money that you raise through the promotion. And the idea is you can't have sort of lavish prizes where the company or the trade association is essentially recycling association funds or corporate funds back into the PAC. So if you're giving away a $700 iPad, you've got to raise $2,100 from the promotion. And if you don't raise that much, the rules say that the PAC needs to then reimburse the corporation, the trade association, whatever the sponsoring entity is, by the difference. There's kind of an example of how that works, sort of more on the 1/3 rule. A popular and sometimes very effective way of raising money for the PAC is through charitable matches. So company or trade association says, for every contribution you make, we'll match dollar for dollar in a contribution to your favorite charity or to a charity among this particular list of charities. The big restrictions there are that the individual contributor to the PAC can't get a tax deduction, and nor can the association or the corporation take a tax deduction. For a long, long time, it was commonly understood that a charitable match could only be based on dollar for dollar, 1-for-1, until earlier this year when the Federal Election Commission considered a complaint against Walmart that was offering a 2-for-1 match for charitable contributions, and the FEC said that that was okay, that the 2-to-1 match was permissible, and that it was even permissible for Walmart to say, and your match is going to go to the Walmart Associates and Critical Need Fund, essentially Walmart employees, the company's own charity. And so that's important for all of you who want to do a charitable match but would like to steer the match to a particular 501c3 group rather than leave it open to the contributor.
As I said before, PACs are one of the most transparent ways to be involved in the process. Regular reports have to be filed with the FEC. That includes donors who give more than $200 in a calendar year by name, address, occupation, and employer. All contributions that the PAC makes have to be disclosed, and all the contributions are available online and searchable and very easy to find. The reporting schedule is such that in an election year, you can either file quarterly or monthly. If you do quarterly, you also have to file pre-primary reports if you're involved in primary elections. So we generally recommend that PACs switch to monthly during an election year so you don't miss one of those pre-primary reports. In off years, you can file semi-annually or monthly. So semi-annually, you file a report in July and the following January or each month. Some PACs that are rather large like to do monthly because they reconcile their books every month and it's just easier to do. Others prefer just to do it once every 6 months. You also have to maintain records for 3 years after the report is filed. Receipts, disbursements, signed prior approvals, all those kind of things. It can be kept electronically so you don't have to keep them in hard copy form.
So PACs are subject to limits just like individuals are. In fact, until a PAC has been in existence for 6 months or more, it's subject to the same contribution limits that individuals are on contributions to candidates. PACs sort of get a boost after they've been around for 6 months, so long as they've made contributions to 5 or more candidates and they've raised money from more than 50 individual contributors. They then sort of can give that $5,000 a year that Ron talked about earlier. PACs can host events for candidates, fundraising events for candidates, where the PAC pays for food and beverages, pays the cost of the event, invites attendees, not only from the restricted class, but from outside of the restricted class. The limit there, again, is that all the funds the PAC spends on a fundraiser for a candidate are limited to that $5,000 limit per election, or if it's a new PAC, $2,700. There's lots of latitude for trade associations, 501c4s, to invite candidates in to meet with the so-called restricted class, meet with executives or meet with the board, and even to include a fundraising appeal as part of that event. So long as you keep the event to your restricted class, you don't have anybody from the outside except perhaps a guest speaker or somebody who's being honored at the event. It's permissible for the corporate entity. This is an exception to the general ban on corporate contributions. It's permissible for the company or the trade association to pay for a breakfast, to pay for another meal, invite the candidate in, ask the restricted class to make contributions to the candidate. The one thing we usually caution against here is that the representatives of the association should not get involved in collecting checks, running around, collecting the checks, sticking them in an envelope, sending them over to the candidate. That kind of activity the FEC views as considered in-kind contribution by the company and can get the association in some hot water. What you want to say for this kind of restricted class event is send your check directly into the campaign. Indicate when you make the contribution that you're making it in conjunction with this event that we're having. But it's a great thing for organizations that want to have a somewhat small meeting with a candidate and not be bound to invite other candidates who are running for the same office.
You can use your PAC in the states. Another sort of color-coded chart. Some states it's very easy. You have to file virtually no forms. Other states are it's a little trickier. You have to file sort of periodic reports on the state forms. You're disclosing sort of the same information. And then there's a few states, the red states, where you really can't use your federal PAC. You have to create a state PAC in those states, or you have some really high hurdles to make it work. But so if you're involved in state races, generally you can use your federal PAC. It may be necessary to create a state PAC, and sometimes you still may want to create a state PAC so that you have sort of separate contribution limits and you have extra money available to do the state stuff as compared to the federal work. And then the final piece to think about is what I call the tax on political activity. If you spend money out of your corporate funds to support a PAC, to make contributions to candidates, there's this tax on the lesser of your net investment income or your political expenditures. So if you have a lot of net investment income, the tax is on your political expenditures. If you have a lot of more political expenditures than investment income, it would be on your investment income. It's kind of an odd little tax, but it's something that is important to think about as you engage in political activities because you've got a budget for it if you're going to have to pay the tax. So with that, we've wrapped up our tour of nonprofit political activity.
And one just a little postscript to, and we have one question here, Camille, postscript to what Ron just said. Ron, correct me if I'm wrong, but if you're, say, a 501c6 trade or professional association and you're subject to the lobbying tax law, to the extent that you're covering political campaign expenditures like the cost of administering your PAC and raising funds for your connected PAC, if those get captured in your lobbying tax expenses, you don't have to pay the 527F tax on those, correct?
That's right. Yeah.
Okay. And question right here.
Quick question. Can a non-connected PAC be converted to a connected PAC?
Yes, you could. If over time, a lot of times what we'll see is that an organization will create a connected PAC and sort of spend down the non-connected PAC, but depending on how much money is in there, it could be done. You could sort of rearrange the bylaws to say it's now a connected organization and file an amended Form 1 with the FEC.
We covered all the material in a short time. Thanks to Ron and Larry for a terrific job. As I mentioned, there's a lot more resources on all of these topics, including some prior recorded webinars. In tomorrow's email, it contains a recording of this program along with the handout materials. We will include some links to some of those prior recorded webinars. And in addition, I forgot to go through the list of all of our upcoming programs. Those will be listed. We're actually scheduled all the way through September. Some terrific programs. Those will be listed with details in tomorrow's email as well. Thank you again for coming, and thanks for